Welcome to this webinar. My name is Sophia Hassel. The General Data Protection Regulation, or GDPR, came into force in May 2018. It grants data subjects, such as you or me, certain rights. And if I want to enforce those rights, specifically in court, then I can bring a claim against a controller or a processor. For example, if they infringe the GDPR, I suffer damage from that infringement, I can bring a claim for compensation under Article 82 of the GDPR. There are two types of damage that I can suffer: material damage, which is economic loss, or non-material damage, which is non-economic loss. The more typical of these two types of damages in the context of GDPR is often non-material damage. So what counts as non-material damage? What do I need to prove as a claimant? Is the compensation only monetary? These questions, among others, are the ones that existed before the first case on non-material damages came along in May of 2023. Since this decision, specifically the Österreichische Post decision, there have been 4 other notable decisions by the Court of Justice. So this webinar will first explore the groundwork laid down by this Österreichische Post decision. Second, look at the new case law to see and flesh out the court's conception of non-material damages. And third, analyze whether a coherent approach emerges from the case law and also perhaps what issues the court still needs to address. So let's start with the first non-material damages case. And let's split it into what happened and what the CGU decided. So what happened? The Austrian Postal Service stored personal data of its customers. They used it to calculate their political preferences, and around 2.2 million Austrians were affected by this. They were tied to a so-called political party affinity. And this was specifically to enable targeted advertisement as well. The claimant in this case was tied to a far-right party. And for him, this was a loss of reputation. He said it caused him great upset, a loss of confidence, and also a feeling of public exposure. And crucially, he never consented to this processing in the first place. The first and second instance courts in Austria said, "We agree, this processing was unlawful. There was no consent." However, they both rejected his claim for damages. They said, "You cannot claim 1,000 euros because in Austria under national law, the damage must have been of a certain significance." In other words, there was a certain threshold that the claimant had to meet in order to gain compensation in the first place. So what did the CGU decide? Well, the Austrian court referred 3 questions. They asked, firstly, is infringement of the GDPR by itself sufficient in itself to confer compensation? Secondly, is there a threshold that the claimant has to reach? And thirdly, how should the court calculate the amount of damage that the claimant should receive? On the first question, they said that the compensation relies on 3 cumulative factors. Firstly, infringement of the GDPR. Secondly, that damage has been suffered by the claimant. And thirdly, that there is a causal link between the infringement and the damage. And it's because these 3 elements are cumulative that the court said that infringement in itself is insufficient to confer compensation. On the second question, the court stated that there is no threshold for non-material damages. And this is quite interesting because in a lot of national systems, such as in the Austrian one, there is a threshold. But the court looked at the wording of Article 82 of the GDPR, and they said here there is no reference to any threshold of seriousness. Moreover, the definition of damages under GDPR, specifically recital 146, has to be broad. And if we were to impose a threshold, then actually this wouldn't be achievable. A broad definition would not be achievable. And lastly, they also said a coherent application of the GDPR would not be possible if each national court has to separately determine what that threshold is and also whether that threshold has been reached. So they said there is no threshold. The impact of this is that wrongdoers should make up for any damage that they've caused, even if this damage is relatively small. On the last question, they said that national courts need to apply their domestic rules regarding the amount of compensation. They said that Article 82 of the GDPR does not require any criteria or does not say much about the assessment and the amount of compensation. So in this case, the law of the member states comes into play. So national courts need to apply their domestic rules regarding the extent of the financial compensation, but it should be noted that EU law principles of equivalence and effectiveness have to also be complied with. So this is the Österreichische Post decision. This is the groundwork of what non-material damages in Article 82 GDPR means. Let's move on now to the second part of this webinar and have a look at what the new cases have added to this decision. And just before we dive into this case law, let's also take a step back and understand why a coherent definition matters so much. The definition of non-material damages will outline whether data subjects can enforce their rights, especially via litigation, and also what responsibilities data controllers have via the GDPR. And I think, to me, it's quite clear that the court understands the importance of the definition and also the coherence of this definition. And we can see this by the way that they have assigned the cases at the Court of Justice. So the way that cases are assigned, for example, through Articles 59 and Article 60 of the Rules of Procedure of the Court, is that once the written procedures are closed, the rapporteur presents a report to the general meeting of the court. And it's in this meeting that the court decides which formation of judges the case should have, but also which chamber the case should go to. And what's very interesting to me, at least, was that every non-material damages case under the GDPR has so far consistently been assigned to the third chamber. And this helps coherence because it means that judges will be familiar with the case law and that they can also start to build upon it gradually. So this leads us back a little bit to our earlier question. How have they expanded the case law then, especially if they're making such a conscientious effort for it to be coherent? And I want to do this by looking at how the court has expanded specifically on infringement, damage, causal link, and then also go into what defenses a controller can raise and the court's definition of compensation. Let's start with infringement. Infringement of the GDPR cannot simply be determined by the fact that there was a data breach. This is what the court said in MediaMarktSaturn, which is one of its most recent cases on non-material damages. They said a national court hearing an action for damages has to take into account first all the evidence that a controller has provided that, for example, their technical and organizational measures were enough, they were secure. Therefore, the court is looking not only at the factual side of an infringement, for example, that there's been a breach, that the data has been disclosed to third parties unlawfully, they're also looking at the intent behind the breach. Is it, for example, that the controller wasn't negligent because they had the sufficient secure and measures in place? Is it, for example, that there was no intent? It seems that if a breach occurs, but a controller can prove that they were not negligent, that there is arguably no infringement and a claim for damages would end here. On the concept of damages, the court has expanded here the most. Recital 85 of the GDPR provides a list on exactly what could constitute material or non-material damage, although it should be noted that as it is a recital, it is non-binding. Recital 85 lists the following. It says loss of control over personal data, the limitation of rights, discrimination, identity theft or fraud, financial loss, unauthorized reversal of pseudo-anonymization, and the loss of confidentiality of personal data, or any other significant economic or social disadvantage to the natural person. The first of this list, loss of control, is the one that has been developed the most by the subsequent case law. The court has clarified that fear deriving from the loss of control is sufficient in itself to give rise to non-material damages. And this is from the case Natsionalna agentsia prihodite at paragraph 80. The amount of time that the fear can be felt by the claimant can be short. In Gemeinde Ummendorf, which was another case, the fear felt by the claimant was only a few days, and it did not have a noticeable consequence on the claimant. This is beyond the fear itself, that is. And I think that this follows actually from the previous decision, the groundwork decision, which said that in doing away with the threshold of non-material damages, if the damage is of a limited scope, there's still a possible claim that can arise. There is no requirement that the damage has to be linked to an actual misuse of the data, nor does the claimant need to prove that there's been a misuse of their data to their detriment. So it is sufficient in the eyes of the court that a breach of the GDPR be linked to the claimant's fear that such misuse may occur in the future. And this is a very broad reading of loss of control. As noted by the Advocate General, the GDPR does not state that fear should create a ground for compensation. This undoubtedly a fine line between mere upset, which is eligible for compensation, and genuine non-material damage, which is eligible for compensation. So the court here could have gone either way, especially in a case on the facts such as Natsionalna, agentsia, prihodite. In this case, the fear suffered by the claimant of a possible misuse of the personal data had no established misuse, and the claimant had suffered no further harm. Nonetheless, because the definition of damages should be broad, as per recital 146, the Advocate General argued that fear in itself should be sufficient. And not only did the court follow the Advocate General's opinion at paragraph 81 of this judgment, but it's actually consistently referred back to it in other judgments. For example, Gemeinde Ummendorf at paragraph 19 and 20, and also MediaMarktSaturn at paragraph 65. The court did not, however, go as far as to establish a presumption that all infringements will result in a damage. So the claimant still needs to show consequences from the infringement. They must show that they have suffered actual damage, however minimal it might be. The burden of proof is also on the claimant to show this damage. And in my view, this makes sense, because especially if it's something like fear, then the claimant is the only one who's in a position to really prove this. It is perhaps due to this logic that the court on the concept of loss of control then also added that the fear has to be firstly well-founded and not hypothetical. While it is for national courts to determine whether these requirements are met, the court used this new criteria to determine that the disclosure of data to a third party who did not know about this disclosure and never became aware of it during the data breach would not give rise to a non-material damage. This was the case of MediaMarktSaturn. It was clear here that the risk was unfounded. The third party, as I said, never became aware of this breach and nor ever encountered this personal data. The document containing the data was returned even within half an hour. So the fear was linked here to a hypothetical risk, and this was proved insufficient by the court for non-material damages. If the claimant cannot evidence a damage, as we have previously discussed, then a successful claim for damages is also going to end here. And remember that the three elements are cumulative. So a claimant will have to prove at each step of the way an infringement, a damage, and a causal link. And that brings me on to the last topic, which is of these three, which is the causal link. And here the court has said the least. We know from the Österreichische Post decision that a causal link has to exist between the infringement and the damage. So it stands to infer that there has to be some sort of reasonable relationship between the two that the claimant has to show. But if there's no causal link, it follows that there cannot be a right to receive compensation under Article 82 of the GDPR. The fact that the damage was caused by a third party, though, instead of the controller themselves, is enough. And here is something that the court has actually expanded upon. It looked at Article 410 of the GDPR, which defines what a third party is. Article 410 says that third parties are often under the direct authority of the controller and are authorized to process the data. But the court again was quite broad when it came to this definition, because in Natsionalna, agentsia, they found hackers to be third parties as defined under Article 410 of the GDPR at 71 of the decision, or paragraph 71. So Article 410 has been defined quite broadly, in the sense that it does not require third parties to be employees of the controller, nor do they have to be subject to its control. It should be noted here, though, that to be causally attributable to the controller, this third-party act that caused the damage, the infringement still has to be attributable to the controller. So in this case, they said it must be that the controller, for example, has caused the infringement by not having the technical and secure measures that they should have had under Article 24 and 32 of the GDPR. So now let's move on to defences and compensation. For defences, this is Article 82.3 of the GDPR, the court has said, liability is subject to fault on the part of the controller, which is presupposed unless it proves that it is not in any way responsible for the event giving rise to the damage. This was at MediaMarkt and also Natsionalna agentsia, and it's also apparently included in Recital 146 of the GDPR. The circumstances in which a controller may claim to be exempt from civil liability, specifically under Article 82 GDPR, is limited to this. It's limited to the breaking of this causal link. And it's explicitly on the controller to rebut this presumption. The court said that this allocation of burden of proof on the controller was actually a way to ensure the effectiveness of the right to compensation under Article 82 GDPR. When it comes to compensation, Article 82.1 has a compensatory instead of punitive function. This is what the court said in MediaMarktSaturn and also Österreichische Post. Compensation is therefore limited to monetary compensation and should only fully compensate for the damage suffered by the infringement for the damage suffered. It cannot go beyond this because it's not punitive. And it's because of this compensatory function that national courts should not look at the controller's behaviour when quantifying non-material damages. The amount of compensation will therefore not be affected by the degree of the controller's responsibility. So it does not matter if there was intent or negligence. In this case, on the controller's side, it will not affect the amount of compensation that the claimant will receive. Final compensation has to be full and effective. This is what Recital 146 of the GDPR says. The court took this to mean that national rules must enable the claiming of compensation. Nonetheless, it is for national courts to determine the exact amount of pecuniary damages in accordance with their national law. However, as long as these internal rules follow the principles of equivalence and effectiveness under EU law. Damages under the GDPR are conceptually autonomous, and therefore special national interpretations, except for the amount, should not occur. In general, the divergence or unity of the GDPR conception of non-material damages and its comparison to national systems will require a way more detailed discussion than what can be afforded in this webinar. But perhaps if it's something you are interested in, then it would be a good article to write about. Last, let us approach our third section of the webinar and analyse the coherence and also the issues. In my opinion, looking at these cases, there is a coherent development of non-material damages cases, especially under Article 82 of the GDPR. If you look at the rulings, they do not radically diverge from each other. The concepts are also reused, they're cross-referenced, they're built upon. And I think really as the case law develops, the courts could even begin to send back some questions now under Article 99 of the Rules of Procedure of the court. And this is when the question referred is identical to the question on which the court has already ruled, or where the answer to such a question may actually be already deduced clearly from the existing case law. But in my view, there are also still some potential issues that need to be addressed. My first one is about Article 82.3 of the GDPR. To me, questions remain over what type of defence it is and also how it relates more broadly to the concept of non-material damages. The case law has only stated that liability, which is the link between the controller's fault and the damage, is presupposed. But this does not necessarily mean that the causal link, which is the link between the infringement and the damage, is presupposed as well. But when you look at the defence of Article 82.3, it says the controller has to prove that it is not in any way responsible for the event giving rise to the damage. And this to me seems a little bit like a defense against causation. You're having to break the causal link. So to me, it's not obvious if Article 82.3 is a defense against causation or if it's a separate defense against general liability. Moreover, if there's a presumption of fault, does this also mean that intent or negligence should become a rebuttable presumption, especially when looking at infringements? So this first part of the 3 cumulative elements that a claimant has to prove. I think these are questions that will now arise before the Court of Justice in the future, and is perhaps something to keep an eye on. My second issue that still remains, and this is more of a practical point rather than a legal point, is about the broad definition of non-material damages. Because I think the definition of non-material damage relates very closely to class action lawsuits and also collective redress, especially bearing in mind the collective redress directive that will be coming quite soon. So a broad definition, what that could mean is that non-material damages become extremely expensive for controllers, to the point that perhaps they may no longer want to operate in Europe. But I think a potential solution to this is not necessarily restricting the definition of damages. I think a solution would be to avoid the creation of an impossible threshold in terms of allowing controllers and processors to prove that they have actually complied with the GDPR. For example, that there's no infringement. And I think it is perhaps for this reason that the court has so far been pretty reasonable with its thresholds, especially if you look at the case of MediaMarktSaturn, because it decided in this case that a breach, an unauthorized disclosure of the data in itself is not enough to hold that an infringement has occurred. You have to look at the intent, you have to look at the negligence. So my last issue, as I come now to the end of this webinar, is I think slightly on burden of proof. There's an interesting case which is not included on the ECLIs of this webinar, but it's the case of Kochner. And if you want to look it up, it's C-755/21. And it's Kochner against Europol. And the court decided here on the concept of non-material damages, although bearing in mind under the law enforcement directive, which is slightly different to the GDPR, that the burden of proof on the claimant would actually be lower. This is because of the opaque nature of proceedings, especially with cases against entities like Europol. But they said in terms of the infringement, that the claimant needs to only establish that the unlawful processing took place in the context of cooperation between Europol and a member state. And in terms of causal link, they said the claimant does not need to show whether it was Europol or the member state who had caused the damage. So these are both lower burdens of proof than perhaps what a claimant needs to prove under the GDPR. And we'll know this more and more as more non-material damages cases come back from the Court of Justice. But I think it's an interesting question nonetheless, especially if we think a little bit about the power asymmetry behind a data subject and, for example, a big tech company who may also have opaque proceedings in the way that they operate, and therefore it could potentially be that the Court of Justice also lowers the burden of proof for non-material damages. Thank you so much for listening to this webinar, and thank you as well to the Academy of Law for inviting me. You can read more about what I've just written, along with all the references to the case law on the European Law blog, and the article has the same name as this webinar. If you have any questions, also please feel free to reach out to me by email or on LinkedIn. I am more than happy to answer any questions that come my way. Thank you so much.